So firstly, there are trademarks, which I think pretty much any business will have. So trademarks protect brands. So if you have a particular name for a product, or even just your house brand for your company, that can be protected with a trademark registration or with trademark rights. So that's the first form of intellectual property, and probably one that everybody should be aware of and make use of. So the next one to talk about designs. So that's a different form of right that protects how things look. So the moment you create a product where you're selling because of the way it looks, you've probably got some value in how you've designed it, and that design can be protected with a registered design right or certain unregistered rights which apply to designs as well. And then moving on from there, we have patents, which again probably most people have heard of, but perhaps not everybody's used. These protect the way things work. So if you've got a particularly good new process or a product that is novel and works in a different way and has some kind of advantage and really sells because of what it does or how it works, then probably patent protection is what you would be looking at if you want to protect yourself and your product. And then kind of related to that, although slightly broader, are trade secrets. So that's another category, and that's quite simply where you keep something as a secret. It's kind of the opposite to patents in some ways, because with a patent you always have to end up publishing what you're protecting. Whereas with trade secrets, the idea is just, well, I will keep it to myself, and that way nobody else can do what I'm doing. Of course, that will only work for certain kinds of inventions or products. So the famous one with trade secrets is the Coca-Cola recipe. So if you have that kind of thing which you can kind of keep to yourself but still use in the marketplace, then it can be very powerful, but it doesn't always work. And then the last one I just want to mention is copyright. So this is an unregistered right which applies to certain kinds of works, literary, dramatic, musical, artistic works. And the moment you create one of those works, you are automatically given copyright protection for it, which will allow you to stop others who have copied what you've done. So the important thing to realize about copyright and other unregistered rights, for example, for designs as well, is that they only protect you if somebody has actually copied. So if somebody has come up with their own version independently, then copyright or unregistered design right doesn't help you. That's different for the registered rights like patents, or if you get a trademark registration as well. For those, it doesn't matter how people have come up with something. If they're within your right, then you can stop them.